Okay. So I won't take any time. We'll straight away jump into that subject. Our first maatladtaru Rakesh. Who will speak first? So see, completely no ways here. We are all about this act. So we want you to explain. English can be. Yeah. Yeah. Wherever you want to. Okay. So, Anjali.
So I thought there was a mic. Shall I speak in English throughout and then later there's a short translation, or should we speak in between? For the YouTube, I mean, I'm just asking. All right. Okay. So thank you very much for having us here today. And last week we had an interaction at the Press Club of India in Delhi. And it was a very useful interaction, and from there the idea emerged that since the Digital Personal Data Protection Act, the Data Protection Law as we call it, is going to affect journalists across the country, it would be a good idea to hold these kind of discussions in different press clubs across the country. So we are really glad and very grateful that, you know, Vanaja, you helped us organize this, and thank you to the press club here for giving us this opportunity to talk about this law, because I think it's something that affects every Indian and certainly affects journalism in the country. So we hope that some action points will also emerge, which we also discussed in the press club in Delhi when the meeting happened. So I'll very briefly give a background to the data protection law and what the provisions of the law are, which are going to impact each one of us as citizens. And now the entire thing had started, the demand for a data protection law, when the Puttasamy judgment came, and the right to privacy was also talked of as a fundamental right. So we know that in a democracy, the right to information is a fundamental right. The Supreme Court of India, in various judgments, has held that the right to information comes from Article 19(1)(a) of the Constitution. Comes from Article 19(1)(a) of the Constitution, which is free speech and expression. And essentially the Supreme Court had said that till people have information, they are not going to be able to formulate their thoughts. Free speech is not possible. Free expression is not possible. So for freedom of speech and expression, it's very important to have the right to information. There was a very strong movement for There was a long movement for a law for the right to information, and the law got passed in 2005. So we've had an RTI law which has been used very extensively by people across the country, and which has also empowered people to access information and hold governments accountable. Governments across the country have been held accountable. So it's been a very empowering piece of legislation. Now, the right to privacy in the Puttasamy. So the right to privacy also now has been declared to be a fundamental right by the Supreme Court in the Puttasamy judgment. And when the data protection law came, the natural kind of expectation was that it would protect people's right to privacy and also people's right to information. Both of them are fundamental rights. It would protect these two rights. Now, the law that has come is unfortunately doing neither. Therefore, it's not just transparency activists who are speaking against the data protection law, even privacy activists, right, which says that information under Section 8, it says that information which would adversely impact the national sovereignty or the security of the country can't be accessed. So Section 8.1a, b, c, d, and Section 8.1j essentially says that it relates to personal information cannot be accessed by citizens if it has nothing to do with public activity or interest, or it causes an unwarranted invasion of the privacy of an individual. So Section 8.1j of the RTI Act balances the right to information with the right to privacy. That was already a balancing role that it was playing. And it said that if there is larger public interest, personal information can still be provided. So, for example, if anybody were to go to a government hospital and say that please give me the list of all the patients and all the treatment that they got, we can't just ask for that kind of information vicariously. That would cause an unwarranted invasion of someone's privacy. But if somebody could prove that my child goes in a school bus and lots of children are traveling in it and the bus driver, their health is of concern, we want some data, they would have to prove public interest to get that data. So the law, the right to information law, was very strong in terms of it being nuanced. It said that you can have information, but not all personal information, because it might cause unwarranted invasion of privacy. And in all the 20 years of the use of the right to information law, because it got implemented in 2005, we are now in 2025, we can't think of a single case where information has been given which is personal in nature, where there has been a problem, where people have said that, look, you gave away my information, it should not have been provided. Where was the need to amend that section? Because now the section has been amended. The data protection law says no personal information can be accessed under the RTI law henceforth. Now, this will have very deep implications, because what is the RTI law being used for? So, for example, let's say a bridge is constructed or a road is constructed, and one rainfall and the bridge collapses or the road breaks. Now, people want to know what happened. Everyone understands there must be some corruption. So people ask for the name of the contractor. They ask for the name of the government official who gave the contract. They ask for the name of the government official who did the inspection and released the money for the road or the bridge. And that's how they fix accountability. Like a journalist or any citizen will then say that, look, you gave the contract to so-and-so, and clearly there has been corruption. That's how accountability is fixed. Again, if one thinks of how the RTI has been used for basic rights. So, for example, people say that our ration we are not getting, our ration cards we are not getting, pension we are not getting. They file RTI requests and ask for the name of the official who is dealing with their application, ration application, pension application, passport application, license application, and then they say, look, they are sitting on this, they demand accountability, so without paying a bribe, they can access their right. Now we will be told that, look, all of this information is personal information, because you're asking for names of officials, you're asking for names of contractors in the previous case. So all of this information is going to go out of the reach of citizens, which makes the RTI law useless for them to demand accountability. So what we are really seeing, that under the data protection law, effectively what the government has done is that we can't anymore access personal information which was needed to demand accountability, to expose corruption, to expose wrongdoing and human rights violations, and which is why a lot of people are now saying that this is less of a data protection law, more of a corruption protection law. more of a prevention of accountability law and access information. One is through the Right to Information Act, and the other way in which all of us access information is if we go directly to people and note down details. So for example, small NGOs, small campaigns, journalists, they go out and do surveys sometimes to try and understand what is happening on the ground. The moment you do a survey, you will write down the name of the person, you will write down their address, their phone number. All of that is personal information. So what the government is now saying through this law is that anyone who collects personal information will be called a data fiduciary. And a data fiduciary has many obligations that they have to fulfill, otherwise there will be a violation of the law. The obligation that is there is to get consent from every person whose data you collect. So for example, I run a small group, some of us run in Delhi, where many women come and they say, we are not getting our ration cards, we are not getting our pensions. We write down the names of those people so that we can, help them filing RTI applications and so on. Now we will be told you're a data fiduciary because you're collecting all this information. Imagine a journalist. You do fact finding. So you go somewhere, let's say there are extrajudicial killings that have happened somewhere. You will go for a fact finding. You will write down the names of the victims. You will write down the names of people who are accused of doing that wrong. And all of that will be called personal information. And if you don't get consent to collect that information, to process that information, you will be violating the data protection law. Now, the important thing here from a journalistic point of view is that the data protection law that has got passed in India has no journalistic exemption. Data protection laws across the world have an exemption for journalists because journalists' job is to really go out and show people the truth. If there is something wrong happening, to expose that, to expose corruption, human rights violation and all. So their work is always exempted. Well, whether it is the GDPR or any other, even the Singapore data protection law has an exemption for journalists. But the Indian law, which got passed in August 2023 and now is going to get operationalized, does not have an exemption for journalists. So that means that when as a journalist you go somewhere, you collect data, you will be expected to get consent from the people whose data you collect or use or publish, because the law says that any processing of personal data is covered and a data fiduciary has to get consent. So you can imagine that a journalist, especially an investigative journalist, if they get information on corruption happening somewhere, they realize that this large bridge was constructed where there has been corruption and allegedly, and the contractor's name or the government official's name they find out, if they were to try and publish it, they have to first get consent from those people. Now, what is the likelihood that somebody who's indulged in corruption or wrongdoing is going to say, yes, I give you consent, please publish my name? It's not going to happen. So this is going to have a huge chilling impact on any kind of real journalism in the country. Anyone who gives consent will basically give it for PR purposes. You know, it will become like a propaganda kind of journalism rather than the real journalism that we require. Similarly, what is now happening under the data protection law is that if there is a complaint, if somebody says that you have violated the data protection law, the complaint goes to a data protection board. And the data protection board is set up at a central level, and the chairperson and members of the data protection board will be selected by the central government. The central government will have the power to remove them, and how they will function will be determined by the central government. So this is very much like a central government body. And this body has been given the power to hear complaints against anyone under the law and impose penalties up to 250 crore rupees, which can be doubled to 500 crore rupees against any person for any case of violation. So can you imagine that now onwards citizens, journalists, when they are bringing out any personal data, they're collecting any data, processing it, will have this worry that if anyone complains, the case will go to the Data Protection Board and we might be fined 500 crore rupees, up to 500 crore rupees. And under the law, it's not just large companies or the government that is covered. Every single individual in the country is covered under this law. Every organization is covered under this law. And the worst part, in many senses, is that the central government is saying, we will decide who's covered under the law and who is left outside the provisions of the law. So the government is saying that government instrumentalities, see who collects the maximum amount of data in the country? It's the government. Under the Aadhaar project and all of that, all our biometrics of 1.5 billion people are lying with the UIDAI. The government under this law is saying that the government instrumentalities don't have to be covered under this. They are exempt from many provisions. The government is saying we will decide which private entity can also be left out. So the fear now is that anyone who is close to the central government, any company, any industrialist who is close to the central government, they give money to the ruling party, they could get an exemption. But anyone, any media house that is very helpful to the central government, is sympathetic to the central government, could be left out of the ambit. But anyone who raises a voice, is critical, could be covered under this law and will have all of these obligations and potentially have these 500 crore rupee penalties that could be imposed on them. So what we are seeing in effect are two things. One is that this is a law where the central government is controlling data. Personal data, and we know how powerful data now is. Nobody can imagine working without data. Central government is under this law collecting the data. They are in any case, repositories of the data, and they're saying we'll control who can have the data. And the second thing is that there is weaponization that is possible of this law. Because the central government has a lot of discretion. The board, the Data Protection Board, is the central government's board. So what can possibly happen is that like the UAPA and the PMLA have all been used to silence critics, similarly this will be another law by which, without criminal proceedings, simply by a complaint to a Data Protection Board, up to 500 crore rupees could be fined. So that is really a power that is being given to the central government effectively, which will result in potential weaponization of this law to silence anyone who's dissenting or is critical. I'll stop here and Rakesh and Amrita.
Ravikant Reddy, my secretary, actually he is supposed to do the program. Come. This is Ravikant Reddy from Hindu. Anjali, Amrita and Rakesh, you know. Okay, yeah. So you want to brief it in Telugu? Yeah.
సో క్లుప్తంగా తెలుగులో సో డిజిటల్ డేటా ప్రొటెక్షన్ చట్టాన్ని పార్లమెంటు కొన్నేళ్ల క్రితం ఆమోదించింది. అయితే ఈ చట్టానికి మూలం కొన్నేళ్ల క్రితం సుప్రీంకోర్టు జస్టిస్ పుట్టస్వామి కేసులో ఇచ్చిన జడ్జిమెంట్. ఎక్కడైతే వ్యక్తిగత సమాచార భద్రత అనేది ఫండమెంటల్ రైట్, అంటే ప్రాథమిక హక్కు అని సుప్రీంకోర్టు చెప్పింది. సమాచారం పొందే హక్కుతో పాటు వ్యక్తిగత సమాచార భద్రత కూడా ప్రాథమిక హక్కు అని చెప్పి సుప్రీంకోర్టు చెప్పింది. దాని నుంచి ఈ చట్టం వచ్చింది. ప్రపంచంలో చాలా దేశాలు, యూరోపియన్ యూనియన్ వీళ్ళందరూ కూడా ఇటువంటి చట్టాలు చాలా ఉన్నాయి. అయితే ఈ చట్టంలో ఉన్న ఒక 2-3 ముఖ్య సమస్యలు అంజలి చెప్పింది. ఒకటి, ఈ చట్టం ద్వారా సమాచార హక్కు చట్టాన్ని అమెండ్ చేస్తున్నారు, సో సవరణ చేస్తున్నారు. సో ఎట్లాంటి సవరణ? సమాచార హక్కు చట్టంలో మీకు అందరికీ తెలిసిందే, ప్రభుత్వం దగ్గర ఉన్న సమాచారం అంతా ప్రజలు తీసుకునే అధికారం ప్రజలకు ఉంటుంది. మినహాయింపులు కొన్ని ఉంటాయి. సెక్షన్ 8 అంటే సెక్షన్ 8లో కొన్ని మినహాయింపులు ఉంటాయి. ఈ చట్టం ద్వారా అంటే డిజిటల్ డేటా ప్రొటెక్షన్ చట్టం ద్వారా సమాచార హక్కు చట్టంలోని సెక్షన్ 81Jని సవరించారు. అంటే 81J మొత్తం సవరించారు. 81Jలో ఇంతకుముందు ఏముండేదంటే వ్యక్తిగత సమాచారం ఏదైనా కన్నా ఒకవేళ ప్రభుత్వం దగ్గర ఉండుంటే ఆ వ్యక్తిగత సమాచారం ఇవ్వకూడదు అని చెప్పి ఇంతకుముందు కూడా చట్టం చెప్పింది. కాకపోతే దానికి కొన్ని మినహాయింపులు చెప్పింది. ఏమని, ఒకవేళ ఆ వ్యక్తిగత సమాచారం కనుక ఏదైనా పబ్లిక్ ఇంట్రెస్ట్కి సంబంధించిందైనా పబ్లిక్ యాక్టివిటీకి సంబంధించిందైనా అయ్యి ఉంటే ఆ సమాచారం ఇవ్వవచ్చు అని ఉండేది. రెండవది అదే సెక్షన్లో ఏం చెప్పారంటే పార్లమెంటుకు కానీ అసెంబ్లీకి కానీ నిరాకరించలేని సమాచారం ప్రజలకు కూడా నిరాకరించవద్దు అని చెప్పింది. అంటే ఒకవేళ లోక్సభ రాజ్యసభల్లో కానీ శాసనసభలో శాసన మండలిలో కానీ ఒక ఎంపీ కానీ ఎమ్మెల్యే కానీ ఏదైనా సమాచారం ప్రభుత్వాన్ని అడిగినప్పుడు వాళ్ళకి ఎట్లా అయితే సమాచారం పొందే అధికారం హక్కు ఉంటుందో సామాన్య ప్రజలకు కూడా అదే ఉంటుంది అని చెప్పింది అనమాట. ఇది ఇంతకుముందు. ఈ రెండింటిని కూడా ఇప్పుడు డిజిటల్ డేటా ప్రొటెక్షన్ చట్టం ద్వారా మార్చారు. ఇప్పుడు సవరణ తర్వాత ఏమిటి అంటే సమాచార హక్కు చట్టంలో 81Jని ఎట్లా మార్చారంటే ఎటువంటి వ్యక్తిగత సమాచారం కూడా ప్రజలకు ఇప్పుడు ఇవ్వబడదు. పబ్లిక్ ఇంట్రెస్ట్ ఉన్నా లేకపోయినా పబ్లిక్ ఇంట్రెస్ట్ అనే క్లాస్ తీసేసాను అనమాట. అంటే ప్రభుత్వం దగ్గర ఉన్న ఏ వ్యక్తిగత సమాచారం అయినా ఇప్పుడు ప్రజలకు పొందే హక్కు ఉండదు. ఎందుకంటే సెక్షన్ 44 DPDPలో సెక్షన్ 44(3) ప్రకారం సమాచార హక్కు చట్టాన్ని సవరించారు. ఇది మొదటిది. సో దీనివల్ల మీరు కూడా అర్థం చేసుకోండి, ప్రభుత్వం దగ్గర ఉన్న చాలా వరకు వ్యక్తిగత సమాచారం జర్నలిస్టులు కావచ్చు ఎవరైనా కావచ్చు మనం వాడుకునేది ఎంతో కొంత ప్రభుత్వ స్కీములు కానీ ప్రభుత్వం చేస్తున్న పనులు కానీ సక్రమంగా జరుగుతున్నాయా లేదా తెలుసుకోవడానికి చేస్తుంటాం. ఇప్పుడు ఉదాహరణకు ఒక స్కీమ్లో లబ్ధిదారుల వివరాలు నేను అనుకున్నాను, మనకు కూడా తెలిసింది ఇప్పుడు ఎన్నో స్కీములు, వేల కోట్ల స్కీములు ఉంటాయి. సో కొన్నిటి స్కీమ్ వెబ్సైట్లే ఉంటాయి, దాంట్లో చాలా వ్యక్తిగత సమాచారం ఉంటుంది, లబ్ధిదారుల పేరు, కొన్నిసార్లు వాళ్ళ ఏజ్ కావచ్చు, జెండర్ కావచ్చు, ఇవన్నీ ఉంటాయి. సో ఇవన్నీ కూడా రేపు తీసుకునే అవకాశం ఉండకపోవచ్చు ఏం జరుగుతుంది అని. తర్వాత ఇది మొదటిది. రెండవది ప్రపంచంలో ఉన్న చాలా వరకు డేటా ప్రొటెక్షన్ చట్టాలు, అది యూరోపియన్ యూనియన్ కావచ్చు, GDPR అంటారు. GDPR అనేది అన్నిటికీ ఒక దాన్ని ఏమంటారు మోడల్ లాగా తీసుకుంటారు. దాని తర్వాత సింగపూర్లో ఉన్న డేటా ప్రొటెక్షన్. ఈ చట్టాలన్నింటిలో కూడా కొన్ని పర్పసెస్ అంటే కొన్ని పనులకి ఆ చట్టం నుంచి మినహాయింపు ఇచ్చారు. సో జర్నలిజం కూడా ఒక పని. అంటే జర్నలిజం కోసం మీరు కనుక వ్యక్తిగత సమాచారాన్ని తీసుకున్నట్టయినా వ్యక్తిగత సమాచారాన్ని ప్రాసెస్ చేసినట్టయినా దానికి ఈ చట్టం నుంచి మినహాయింపులు ఉంటాయి వేరే దేశాల్లో. ఈ GDPR కానీ ఇంతకుముందు చెప్పినట్టు GDPR కానీ సింగపూర్. కానీ మన చట్టంలో అటువంటి మినహాయింపులు ఏవీ లేకుండా చేశారు. సో ఎవరికి కూడా, మీకు కానీ ఇంకెవరికి కూడా మినహాయింపు లేవు. సో మినహాయింపులు లేకపోవడం వల్ల వచ్చే నష్టం ఏమిటి అంటే పౌరుల వ్యక్తిగత సమాచారం ఎవరు కలెక్ట్ చేసినా వాళ్ళందరూ కూడా డేటా ఫిడ్యూషియరీ అంటే డేటా బాధ్యులు. అంటే మీరు కలెక్ట్ చేసిన వాళ్ళు అవుతారు. అంటే వ్యక్తిగత సమాచారం అంటే ఏమైతుండొచ్చు, మీరు ఫీల్డ్లోకి వెళ్ళి ఒక నలుగురు ఎవరికైనా బాధ్యులతో మాట్లాడారు అనుకోండి, వాళ్ళ పేర్లు రాసుకుంటారు, వాళ్ళ ఫోన్ నెంబర్లు రాసుకుంటారు, వాళ్ళ స్టోరీ రాసుకుంటారు, అవన్నీ కూడా మీరు ఎక్కడనో టైప్ చేసుకుంటారు, ఫోన్లో పెట్టుకుంటారు టైప్. అదంతా కూడా ఆటోమేటిక్గా ఈ చట్టం ప్రకారం డిజిటల్ సమాచారంగా భావించబడుతుంది, వ్యక్తిగత సమాచారం. సో ఈ వ్యక్తిగత సమాచారం ఎవరైతే తీసుకుంటారో ప్రాసెస్ చేస్తారో వీళ్ళందరూ కూడా కొన్ని పనులు చేయాల్సి ఉంటుంది. ఒకటి కన్సెంట్, అంటే తప్పనిసరిగా ఎవరి సమాచారం అయితే మనం తీసుకుంటామో వాళ్ళ అనుమతి తీసుకోవాలి, ఎందుకు తీసుకుంటున్నామో వాళ్ళకు చెప్పాలి, ఇవన్నీ కూడా ఎవరైనా చేయాల్సిన పని. సో దీనివల్ల డేంజర్ ఏంటిదంటే ఇన్వెస్టిగేటివ్ జర్నలిజం ఇట్లాంటి మీరు చేసే చాలా పనుల్లో కొంతమందికి వ్యక్తిగత సమాచారం తెలిసినా కూడా వాళ్ళే ఒకవేళ ఏదైతే స్కామ్ అనుకోండి, ఇంకోటి కరప్షన్ అనుకోండి, దాంట్లో ఉన్నారనుకోండి, సో తప్పనిసరిగా మీరు వాళ్ళకి పోయి మీ గురించి రాస్తున్నాము, మీ సమాచారం మా దగ్గర ఉంది, మీరు అనుమతిస్తారా అంటే వాళ్ళు ఎట్లా అనుమతి ఇవ్వరు. సో వీటన్నిటి వల్ల జర్నలిజం మీద మిగతా అన్నిటి మీద చాలా ఎఫెక్ట్ పడబోతుంది. సో అని ఇంకొకటి ఏంటంటే ఈ చట్ట ప్రకారం డిజిటల్ ఏమైనా కంప్లైంట్స్ కానీ ఫిర్యాదులు ఉంటే డేటా ప్రొటెక్షన్ బోర్డు అనేది ఒక బోర్డు ఉంటుంది. సో ఈ బోర్డు కేంద్ర ప్రభుత్వం నియమిస్తుంది బోర్డు చైర్పర్సన్, బోర్డు తర్వాత బోర్డు సభ్యులను. ఎవరికైనా ఈ చట్ట ప్రకారం ఏమైనా ఫిర్యాదులు చేయాల్సి ఉంటే ఆ బోర్డుకి ఫిర్యాదు చేయవచ్చు. ఆ బోర్డు ఒకవేళ కనుక ఎవరన్నా అంటే ఈ చట్టాన్ని ఉల్లంఘించారు అని అనుకుంటే దగ్గర 500 కోట్ల వరకు పెనాల్టీ కూడా విధించవచ్చు ఎవరైనా సరే. అంటే ఆ డేటా బాధ్యుడు ఎవరైనా సరే, ఫిడ్యూషియరీ అంటాం కదా. సో దీనివల్ల ఈ నష్టాలన్నీ ఉంటాయి.
So, does this law apply to journalists? If you read the law, it will not say anywhere that it applies to journalists. But I'm going to read out 3-4 definitions, and then I'll highlight the Editors Guild letter, which explains what will be the impact on journalists. So first of all, who is a data fiduciary? So this is a definition in section 2I. It says data fiduciary. So fiduciary relationship is like between a lawyer and a client, between a doctor and a patient, which requires a certain sense of confidentiality. So data fiduciary I'm not sure if Telugu has a word. A relationship of trust, basically. So data fiduciary means any person who alone or in conjunction with other persons determines the purpose and means of processing of personal data. So it means any person alone or two of us or in an organizational format. So if simply two freelance journalists decide to go and start investigating, let's say anything, I mean, they could be looking at hunger deaths, you know, what we saw in Odisha recently in the mango kernel case, etc., anything. And the word person means an individual, an organization, a company, a firm. So any person who alone or in the form of an organization goes around collecting and processing personal data. The definition of processing is, processing means in relation to personal data, a wholly or partly automated operation or set of operations performed on personal data, and this includes collection, recording, organization, storage, use, combination, sharing, disclosure, dissemination. So semi-automated or automated means that if you simply scan this information, it becomes automated processing. If you put this into Excel and you give a simple function like summation or auto numbering, it meets the threshold of processing. These days, even if we collect data by hand, typically we'll take a photograph of it and then send it to our organization or share it. The moment you're disseminating it, so let's say you did everything in a non-digital mode, but finally you put it up on your Twitter or on your Facebook or on a website, this will get hit by this particular section. So journalists are fully covered under this law. You will not find the word journalist written anywhere, but if you read these particular definitions, it's very, very clear that journalists are covered. Now this is a letter written by the Editors Guild of India, which they wrote to Mr. Vaishnav, who's the Minister of METI, and they highlighted that two fundamental rights of journalists are getting directly hit by the provisions of this Data Protection Act. First of all, Article 19(1)(a), which is freedom of speech and expression. All journalists in our country derive their right to do journalism under 19(1)(a). So they highlighted that just the basic act of collecting information, of storing, using information gets impacted. Also, the Right to Information Act, which Anjali and Rakesh have both spoken about, emanates from Article 19(1)(a). That's amended. And the other is the right to pursue an occupation of your choice. They said once a law like this comes in, we will be unable to carry out journalism. Now they've highlighted 5 specific provisions, and I'm just going to flag them, not sort of read them out in full detail. The first provision that they flagged is that every data fiduciary has to provide notice where processing is based on consent and obtain written and specific consent. So exactly the examples that were being given, that if you're going and investigating the falling of a bridge or derailment of a train, and you go and you find something that, okay, the inspector didn't actually wave the correct flag at the correct time, or there was some other human error, in order to report on that, in order to collect that information and put it in the public domain, you will need consent of those very parties who you have found through your investigation to be involved in this. The second particular provision that they are saying is that the requirement to process information only for specified purpose. So what happens is that, let's say you're interviewing someone and you're taking their consent. In the consent, you have to tell them that what is the purpose of this information and how you will use it. What the Editors Guild has highlighted is that very often journalists may start with the exploratory work. You may seek consent, let's say you're even interviewing any one of us. You may seek consent at that point to say that, no, I'm only asking for consent and I'll only use it for this purpose. But as your story develops, you may want to use that information in a different context. You may suddenly realize that, okay, originally I interviewed the contractor only asking this, but now I realize additional things. You will have to go back and say that I have come upon new information. Now I want to use it in this way. Now are you allowing me to use it in this particular way? The third thing is that the Data Protection Act enables the data principal. Data principal is the person whose personal data you've collected. It enables the data principal to withdraw consent at any point in time. So if the data principal gets to know that you found something very damning about them and you're about to publish it, they might call you and say, I revoke all the consent that I had given. After which, if you're publishing their name and any personal information, there's going to be very, very deep trouble. Then section 36 of the Data Protection Act has been highlighted by the Editors Guild of India, and we believe that section 36 is an extremely draconian section which has zero guardrails. So I'm just going to read it out. It says the central government may, for the purposes of this act, require the board and any data fiduciary to furnish such information as it may call for. It doesn't say in the interest of national security, it doesn't say upon violation of a law, it doesn't say upon offense or commission of a crime. It simply says that the central government can ask any data fiduciary, which means any journalist, to come out and to give them any information. It doesn't say information. I mean, these sort of provisions are not there for the police, they're not there for investigative agencies. Like Anjali and Rakesh both mentioned that usually in criminal cases there's a threshold. There has to be an FIR, there has to be a summons. Over here it doesn't even say that you need a written notice. Maybe they can call you and say that, listen, you did this story, better turn up before us and show us your phone. Who was your source? Give us the password to your Gmail account. Give us the password to your Instagram account. It is with zero guardrails. I mean, this is like surveillance to a level that we haven't seen till now. So they're highlighting this and they're saying after this, how will journalists do source-based journalism? How will you protect your sources? There might be people often in even security establishments who are talking to you on the basis of confidentiality and security. What happens to all of that? And of course, the fifth thing that they've highlighted in their letter is the question of the amendment of the Right to Information Act itself. If we look at some recent great journalistic work, I think one example that really stands out is how the media analyzed all the disclosures related to the electoral bonds case. When the Supreme Court said put all that data out in the public domain, within a few hours, the media had made these charts telling us, this contractor gave money to this government and then that government gave this contract to this company, or then they changed the law in order to suit this company, they changed a certain policy. Now we are saying that even if that data was to be out in the public domain, let's say the Supreme Court ordered such data to be out in the public domain, you would not be able to process that data, because what did the journalists do? They basically downloaded all of that data, put it into Excel, then they downloaded all the contracts data, put that into Excel and quickly ran a matching exercise saying that, okay, where all does the name of this company show up? And then they connected it back to who are the directors of the company, etc. All of that journalistic exercise is completely outside the purview. In fact, we have been examining this more in the context of particular examples. Within the electoral bond example itself, if you take a step back and you look at what is the information that the Supreme Court relied on to give its judgment. So actually, it was under the RTI law that all the correspondence between the RBI, the Finance Ministry, the Election Commission of India and the Finance Ministry had been accessed, and it was in that correspondence that the Supreme Court relied on, because the RBI was red flagging saying don't do this is really dangerous, it will lead to money laundering, it will cause a lot of problems, you'll have cross-country smuggling of these bonds, you could have counterfeit bonds, how are you going to, and they also said that when you're fighting black money you can't have this kind of secret scheme. Similarly, the Election Commission of India said that how will we monitor parties if we don't know where their funds are coming from? Now, all of this correspondence had the names of the officials. It said, the governor of RBI, Mr. So-and-so, in a meeting with the finance secretary, Mr. So-and-so highlighted the following concerns. Now, post this law, even if we were to get our hands under the RTI law on such correspondence, it would all be blackened out. You wouldn't know who said what to whom. So all that you would get is, yeah, someone's highlighting something, but all the names would be blackened out. Again, the Supreme Court relied on file notings. Which officer overruled the Election Commission of India's objections? There was a meeting that happened with the Election Commission in which the three commissioners, the secretary of the commission and the finance secretary, all of them sat and the minutes of the meeting document that so-and-so said this, after which so-and-so replied like this. And all of this is reproduced in the Supreme Court judgment. And they said that, look, when the regulatory bodies are saying, don't do this, why are you doing this? We will not get that information now. You will not get to know who sat in which meeting and who said what. Tomorrow, let's say there's let's say the central government says or the state government says we are taking over land of this university, or we are giving away land to so-and-so. And you ask for the minutes of the meeting. You say, who authorized it? You're not going to get that information. Who attended which meeting? Who did the government talk to before bringing a law? Already on the data protection law, during the framing of the law and the rules, we have been asking that who are you talking to? Because you're not talking to civil society. No civil society has been brought in on the dialogue. And they've given in RTI responses, we cannot tell you who we are talking to. So how are you going to sort of, raise of accountability? These are very, very serious concerns. And just the last point that I'll end with, Niti Aayog itself said that this law is very, very problematic. The Niti Aayog pointed out one particular provision. They said that when you've amended the RTI law to say that henceforth all personal information is exempt, they said now what will happen to personal information of public officials? So for example, assets and disclosures of public servants, assets and disclosures of even government servants, of candidates. What about who's taking part in what deliberation? This is the Niti Aayog. This is not a civil society group saying, this is Niti Aayog saying that if you make these amendments, how will people seek accountability of the government? Even these objections were not taken on board. So I'll stop here and Rakesh.
సో ఈ చట్టం గురించి ఎడిటర్స్ గిల్డ్ వాళ్ళు కూడా ప్రభుత్వానికి ఇన్ఫర్మేషన్ టెక్నాలజీ మినిస్టర్ అశ్విని వైష్ణవ్ గారికి రాసిన లెటర్లో కూడా వాళ్ళు 5 ముఖ్యమైన విషయాలు హైలైట్ చేశారు. ఒకటేమో కన్సెంట్ అంటే అనుమతి తీసుకోవడం గురించి. సో అనుమతి తీసుకోవడం కొన్ని సందర్భాల్లో సాధ్యమైనా చాలా సందర్భాల్లో సాధ్యం కాదు. రెండవది పర్పస్, అంటే మీరు అనుమతి తీసుకునేప్పుడు ఏదైతే నేను దేనికోసం ఈ డేటాను వాడుకుంటున్నాను అని చెప్తారో, ఒకవేళ ఆ పర్పస్ మారిందనుకోండి మధ్యలో, మళ్ళీ ఆ డేటా ఎవరి దగ్గర అయితే తీసుకున్నామో వాళ్ళ దగ్గరికి పోయి మేము ఇంతకుముందు దీనికోసం అని చెప్పినాము, ఇప్పుడు వేరే దానికోసం వాడుతున్నాం అంటే వాళ్ళు ఒప్పుకునే పరిస్థితి ఉండదు. సో అదొకటి. మూడవది, ఎవరి డేటాను అయితే మనం తీసుకుంటున్నామో వాళ్ళ డేటా ప్రిన్సిపల్ అంటాం, వాళ్ళు ఎప్పుడైనా వాళ్ళ అనుమతి విత్డ్రా చేసుకోవచ్చు. అంటే ఈ రోజున ఒక ఆయన సరే నా స్టోరీ చెప్పుకోండి అంటారు, రేపు వాళ్ళ ఎవరైనా బెదిరించవచ్చు, ప్రలోభానికి గురి చేసి ఏవైనా కావచ్చు. సో వాళ్ళు వచ్చి వాళ్ళు కనుక విత్డ్రా చేసుకుంటే వాళ్ళ అనుమతి, మనం ఆ అనుమతి విత్డ్రా చేసుకున్న తర్వాత కూడా మనం ఒకవేళ ఆ సమాచారాన్ని ప్రాసెస్ చేయడమో లేకపోతే ఇక్కడ పబ్లిష్ చేయడం జరిగితే మనం ఈ చట్టాన్ని ఉల్లంఘించినట్టే ఎవరైనా. తర్వాత నాలుగవది, ఇంతకుముందు చెప్పినట్టు చట్టంలోని సెక్షన్ 36, ఇక్కడ సెంట్రల్ గవర్నమెంట్ ఈ చట్టం కింద ఎటువంటి సమాచారం అయినా, అంటే ఈ ఫిడ్యూషరీ దగ్గర ఉన్న ఎటువంటి సమాచారం అయినా తీసుకునే హక్కు ఉంది. సో ఓవరాల్గా ఇది అంటే తను చెప్పినట్టు నీతి ఆయోగ్ కూడా ఇప్పటికే చాలా చట్టాలు మీరు చూస్తే కనుక, ఉదాహరణకు మనకు ప్రజాప్రాతినిధ్య చట్టం ఉంది. ఎన్నికల్లో పోటీ చేసే క్యాండిడేట్లంతా వాళ్ళ అఫిడవిట్లో అన్ని వివరాలు ఇస్తారు, ఎక్కడ ఆస్తులు ఉన్నాయి, ఏ కేసులు ఉన్నాయి, అప్పులు ఎక్కడ ఉన్నాయి ఇవన్నీ. సో వీటన్నిటి గురించి ఏమవుతుంది నిజంగా ఒకవేళ ఈ చట్టం వస్తే, అవన్నీ వ్యక్తిగత సమాచారం, నిజంగా చెప్పాలంటే వ్యక్తిగత సమాచారం. ఐఏఎస్ ఆఫీసర్లు ప్రతి సంవత్సరం తర్వాత ప్రభుత్వ ఉద్యోగులందరూ కూడా వాళ్ళ ఐపీఆర్ అంటే ఇమ్యూవబుల్ ప్రాపర్టీ రిటర్న్ సబ్మిట్ చేస్తారు ప్రభుత్వానికి. సో వీటికి ఏమవుతుంది, ఇవన్నీ పబ్లిక్లో ఉన్నాయి ఇప్పుడు. తర్వాత ఇప్పుడు లబ్ధిదారుల వివరాలు చాలా వరకు పబ్లిక్లో ఉంటాయి, బెనిఫిషియరీ డీటెయిల్స్, వీటికి ఏమవుతుంది. రేపు ఫైల్ నోటింగ్స్లో ఇప్పుడు ఉదాహరణకు మీరు సమాచార హక్కు చట్టం కింద సెక్షన్ 4లో ప్రభుత్వ ఉద్యోగుల పేర్లు, వాళ్ళు ఏమేం చేస్తారు, వాళ్ళకు వచ్చే జీతభత్యాల వివరాలు కూడా ఎవరు అడగకముందే స్వచ్ఛందంగా వెల్లడించాలి, వాలంటరీ డిస్క్లోజర్. సో అవి చాలా వెబ్సైట్లో ఇప్పటికీ మీకు కనబడతాయి. సో వాటికి ఏమవుతుంది. సో ఇవన్నీ కూడా ఈ ప్రశ్నలన్నీ కూడా నీతి ఆయోగ్ లేవనెత్తింది. ఒకవేళ మీరు సమాచార హక్కు చట్టాన్ని సవరిస్తున్నారు కాబట్టి వీటన్నిటికీ ఏమవుతుంది. సో వీటన్నిటికి సమాధానం లేకుండా ఈ చట్టం కనుక ముందుకెళ్తే అంటే మొత్తం కూడా ఒక కేంద్రీకృతమే ప్రభుత్వం చేతిలోకి వెళ్తుంది. వాళ్ళు ఏం చెప్పదలుచుకున్నారో అంటే అట్లీస్ట్ వ్యక్తిగత సమాచారం వరకు అది అవుతుంది. సో అదే అండి, అంటే ఇవన్నీ కూడా సిమిలర్ హైడ్. ఒకటి ఏంటంటే మనకి ఎక్కడ కూడా రాష్ట్రాల్లో కానీ ఎక్కడ దీని గురించి చర్చ జరగట్లేదు. ఎందుకంటే ఈ చట్టం పెద్ద ప్రజలకు సంబంధించింది కాదు అని చాలా మందికి ఒక అపోహ లాగుతుంది. ఎందుకంటే ఇది పెద్ద పెద్ద కంపెనీలకు, వాళ్ళు ఇప్పుడు మనం వాడే సోషల్ మీడియా కంపెనీలు కానీ ఇవన్నీ కూడా వాళ్ళు మన డేటాను ఎట్లా వాడతారు అన్న దానికోసం వచ్చిన చట్టమేనేమో అని ఒక భావన ఉంది. అది కొంతవరకు నిజమే. ఈ చట్టం రావడానికి కూడా సుప్రీంకోర్టులో జరిగిన వాదనలు అన్నీ కూడా అదొక కారణం. కాకపోతే ఆ చట్టం వాటితో పాటు మిగతా చాలా సందర్భాల్లో మనకు నష్టం చేసే ప్రొవిజన్స్ ఇందులో ఉన్నాయి. సరే ఆ కంపెనీలను ఎట్లా కంట్రోల్ చేయాలి అదంతా ఒక ఎత్తు అయితే, సుప్రీంకోర్టు ఆ జడ్జిమెంట్లో చెప్పింది కూడా వ్యక్తిగత సమాచారం ప్రైవసీ ప్రాథమిక హక్కు అని చెప్పింది, కానీ వ్యక్తిగత సమాచారం మొత్తం ఇవ్వకూడదని ఎక్కడ చెప్పలేదు. సో దాన్ని వేరే విధంగా ఇంటర్ప్రిట్ చేసుకొని ఒక పర్పస్ కోసం అని చెప్పి, సో చాలా మందికి అసలు ఈ చట్టం మన కోసం కాదు అన్న ఒక అపోహ ఉంది సాధారణ ప్రజల్లో. సో మనం అంటే అందరూ మాట్లాడాల్సిందంటే దీనివల్ల అందరికీ, అంటే అది జర్నలిస్టులు ఒక్కరనే కాదు, సామాన్య ప్రజలకు కూడా దీనివల్ల చాలా రేపు నష్టం జరిగే అవకాశం ఉంటుంది. సో ఇప్పుడు మీ ఎవరైనా ఫర్ ఎగ్జాంపుల్ ఎవరైనా సమాచారం కలెక్ట్ చేసుకున్నారనుకోండి, ఇప్పుడు పిల్లలే ఉంటారు, కాలేజ్ స్టూడెంట్స్ ఉంటారు. సో చాలామంది కాలేజ్ స్టూడెంట్స్ ఏదో ఫెస్ట్ కోసమో దానికోసమో గూగుల్ ఫామ్స్ పంపించి మీ డీటెయిల్స్ ఇవ్వమంటారు. సో నిజంగా మీరంటే ఇష్టం లేని వాళ్ళు ఎవరు ఉన్నారనుకోండి, నా అనుమతి లేకుండా తీసుకున్నారని చెప్పి ఆయన కూడా కంప్లైంట్ చేయొచ్చు. సో దీని చాలా మిస్యూజ్ అయ్యే అవకాశం చాలా ఉంటుంది చట్టం ద్వారా. ఇప్పుడున్న అంటే ఈ చట్టాన్ని సవరించకుండా ఇట్లానే అమలు చేస్తే ఎవరైనా, అంటే ఇది ఏదో మనం డేటా అంటే మనం డేటా కలెక్ట్ చేయం కదా అని మనం అనుకుంటుండొచ్చు, మనకు తెలియకుండానే చాలా డేటా మనం కలెక్ట్ చేస్తున్నాం. మీరు వాట్సాప్లో ఉదాహరణకి మీ ఫ్రెండ్ ఎవరో మీకు ఒక ఫలానా అతను తెలుసు, ఆయన ఫోన్ నెంబర్ పంపిస్తామని అడిగింది అనుకోండి, మీరేమంటారు? వాళ్ళని అడగాం కదా మనం, సరే మనకు తెలుసు కదా, ముగ్గురికి కామన్ ఫ్రెండే కదా, మనం పంపిస్తాం. మీరు టెక్నికల్గా చెప్పాలంటే మీరు డేటా ప్రాసెస్ చేసినట్టే, ఎందుకంటే ఫోన్ నెంబర్ అనేది వ్యక్తిగత సమాచారం. సో వాళ్ళని అడగకుండా మీరు ప్రాసెస్ చేశారు కదా. సో మీ మీద గిట్టని వాళ్ళు ఉంటే మీ మీద కూడా. సో అంటే ఈ చట్టం ఏదో పెద్ద పెద్ద కంపెనీల కోసం వాళ్ళ కోసమే కాదు, సరే వాళ్ళ కోసం ఉన్నా కూడా మనందరం కూడా ఒకవేళ ఇట్లానే అమలు చేస్తే మనందరికి కూడా చాలా నష్టం చేసే అవకాశం ఉంది. కాబట్టి ఈ ఒకటి మినహాయింపులు, క్లియర్గా మినహాయింపులు చెప్పాలి. అంటే ఒక 1000 కోట్లు, తర్వాత కోట్ల మంది సమాచారం తీసుకునే కంపెనీలు, తర్వాత నార్మల్గా వేరే పనుల కోసం చేసే సమాచారాన్ని ఒకే ఘాటిని కట్టలేదు, రెండింటిని కంపేర్ చేయలేము మనం. సో ఆ డిస్టింక్షన్ ఉండాలి. సో ఆ డిస్టింక్షన్ ఉండడంతో పాటు ఈ రాష్ట్రాలకు కూడా ఈ చట్టం కింద అధికారం లేవు. మిగతా పక్కకు పెట్టి రాష్ట్ర ప్రభుత్వాలకు కూడా ఎటువంటి అధికారం లేదు. ఎగ్జామ్షన్ ఇవ్వాలన్నా, ఎటువంటి సమాచారం ఎవరికి ఎగ్జామ్షన్ ఇవ్వాలన్నా అది కేంద్రం చేతిలో ఉంది, రాష్ట్రాలకు కూడా అధికారం లేదు. సో ఇవన్నీ కూడా మనం ఆలోచించాల్సిన విషయాలు. ప్రజలకు కూడా చెప్పాల్సింది ఏంటంటే ఇది కేవలం పెద్ద పెద్ద కంపెనీల కోసం కదా, అంటే మనకి ఇవాళ అర్థం కాకపోవచ్చు, అంటే ఒక కేసు అయ్యే వరకు మనకు అర్థం కాదు. సో ఇది అందరికి కూడా నష్టం చేస్తుంది. ఈ ఇప్పుడున్న పద్ధతిలో కనుక రూల్స్ వచ్చి నోటిఫై అయితే దీన్ని మార్చాల్సిన, సవరణ చేయాల్సిన అవసరం చాలా ఉంది.
Now the floor is open for questions. Being on the stage, I'll take the advantage of asking first questions. Sorry, shall I? Can I? Okay. So you said individual organizations can be exempted, right? This is the same thing in Broadcast Bill 2024 also. There is some specifications what kind of organizations they can exempt. We clearly know what kind of organizations they are, right? So I won't be exempted, but I know who will be exempted, right? So do they have similar thing here? When they say individual organizations can be exempted, are they saying what kind of organization? Is it there? Number one. Two, see, there are laws in the country, in the world. There are, general natural justice system. We journalists always have this thing that we will not reveal our source. That is our fundamental right. So is this going to cancel that right? This law is going to cancel that right? And RTI is, RTI has brought basing on a fundamental right, right? So this is not, this law doesn't go with the fundamental right of what, that has that fundamental right protection. How can this be superior than that? These are 3 questions.
Shall we answer those, or do you want to take more questions? Maybe just answer that and then. So 3 questions you raised, I'll try and answer, and of course Amrita and Rakesh can join. The first thing is that the question that you asked is it a class of people, of data fiduciaries that can be exempted under the law? And the answer is no. Anyone, it's pure discretion of the central government. So under many laws, somebody might say that any person who's dealing with national security, those organizations can be exempted. Somebody could say all media exemptions could be exempted. The problem, however, in this law is that there is no class exemption. It's individual exemption, both of the government agencies and of the private entities. So,
for example, yes. They can exempt ENADO and they can...
Absolutely. So it's up to the central government. So for example, one of the things that we have been saying should concern opposition parties also is that today if we look at the way in which elections are held, no party can actually exist without having their social media IT cells. All of them collect names of voters, their phone numbers, send messages to them. Now, in this particular case, the ruling party, whoever it might be at the center, today it's the BJP, tomorrow it could be anyone, they can exempt their own IT cell, but the opposition party IT cells would not be exempted. So they will then run the risk of having complaints filed against them. And imagine if even 10 complaints are filed against a large political party, it will result in 5,000 crore rupees of fines potentially. So which party will be able to exist? So what we are seeing is that if there is a media house which is really very sympathetic to the central government might exempt that media house but not exempt the other media outlets or journalists. So there is no class exemption. There is a pure discretion that is given to the central government of India. And here I think it's worth noting that this really hits at the federal structure of the country. Because let's say in the right to information law, there are information commissions in every state. And here there is only one data protection board which is central and which is being controlled by the central government. So anyone in the country, if they say anything or do anything which the central government is not happy about, then there could be these repercussions that we have discussed. The appointment, removal, everything is in the control of the central government. So this is very draconian in that sense. The second question that you talked about was the sources. And like Amrita read out, Section 36, Section 36 of the law, it's unheard of, where, you know, the government, central government is being given the power to ask anyone who's a data fiduciary for any information. So this will include, in the case of journalists, their sources as well. The central government could say that we want to know the sources, and there is no way that you can deny it under this law. Now, this law does say that if there is any other law for the time being in force, then that law, the provisions will stay. But there doesn't seem to be any law as such, a statute that protects journalists from giving out their sources. So that means this law will be supreme. Yes, so tradition is not accounted for, and the Editors Guild, I will just read out what they have said. They have said Section 36 of the Data Protection empowers the central government to require any data fiduciary to furnish any information it may seek. So, preserving the confidentiality of sources is integral to investigative journalism, as journalists often rely on such informants for sensitive information. Journalists acting as data fiduciaries are not exempted from this provision. So that will essentially mean this will likely deter potential informants from coming forward with necessary information for fear of their anonymity being compromised, thereby having a debilitating impact on journalism at large. So there is no exemption under the law for this kind of activity. You said that this is not coming under any fundamental right, whereas the right to information is a fundamental right. But unfortunately, what the government is relying on, or what this law is relying on, is the Puttasamy judgment, in which the right to privacy was upheld to be a fundamental right. But the problem is that this is not even protecting privacy. Because privacy would be protected, data would be protected if the government were to say wherever there might be personal data, we will protect it. Here the government is saying no. Government instrumentalities exempt. Anyone else holding big data could be exempted by the central government on their whims and fancies. So this is not really protecting anyone's personal data. The intention, therefore, as people are seeing it, seems to be twofold. One is that the government doesn't want anyone to hold them accountable, which could be journalists or it could be citizens. And two is that this will give a weapon in the hand of whoever is in the central government to say that if you say anything that is inconvenient to us, the matter could go to the board and 500 crore rupee penalties could be imposed on you. So that is really what the fear and the worry is under this law. And we are seeing that once this law comes, all public authorities will very quickly want to comply with the provisions of this law. So if we see in the recent elections, all political parties, opposition parties have been worried about the voter lists. They are saying that names of people who live there are being deleted arbitrarily. Names of people who don't live there are being added to the voter list. And so there is electoral fraud. That is something that is a worry. What is the way to address that? It is to say that all voter lists are in the public domain. Anyone can check. Anyone can point out if there is anything wrong. Now, after this law becomes operational, the Election Commission of India could say, look, the electoral list, the voter list has people's names on it. It has their addresses, it has their photographs. All of this is personal information. Because personal information is defined as anything that identifies a person, an individual. So this is personal information. They might turn around and say, we will not put it in the public domain. So how do you fight electoral fraud? So this will have very, very serious ramifications for democracy as a whole, and which is why there is such a lot of concern around it. Unfortunately, because this bill was brought in August 2023, when the Manipur situation was being debated in the parliament and all of the opposition had staged a walkout. The bill was brought at that time. There was no debate on the bill. At that time, they staged a walkout and the bill was brought in. The bill was not debated. Even the amendments that the opposition had suggested, because the numbers were in such a way that the law was passed. So not enough information like the Waqf bill has come. Because there was so much debate in parliament, people know what the problematic provisions are. Here nobody knows. And so what people are realizing is that this law has got passed and we have no idea what the dangers of this law are. And that is the reason why we are very grateful that you have done this discussion today, because we need to really understand what is there in this law which is going to be so dangerous. And the law has not been rolled out. It has not been implemented because the rules are still being drafted. So the demand really is that don't roll out the law, don't implement the law in its current form. Please review the law, amend the law in the parliament, and only then should this law be brought. Otherwise, RTI, free press, media, all of that is going to be affected.
So, no, thank you, Anjali, Amrita, and Rakesh for this session. You mentioned that the Editors Guild has listed out the objections and the concerns that are there. Has there been any response from the government on that front? Second is, has anyone been able to go to court on this? Legal challenge is perhaps the only way out. And third, you are here for the Bharat Summit. Obviously, like you mentioned, it's a federal government concern as well, the federalism concept concern as well. So have you been able to reach out to parties like the Congress or other regional parties? Because very obviously, data is going to be very critical in fighting elections or governance and everything else as well. So there is obviously a larger concern than just journalists, but journalists is obviously the crux of what we are seeing.
So if I can start in the reverse order, and then I think Amrita and Rakesh can take up some of the questions. Yes, we have been reaching out to all parties, to the opposition parties, and also, of course, to the ruling party with our concerns. The concerns have been flagged in various stages and in different forms. When the bill was being drafted, we sent our concerns to METI, which is the ministry in charge. Unfortunately, there was no response. Even the Editors Guild letter that you talked about, there has been no response from the central government so far on this. The opposition parties they were part of the JPC, the Joint Parliamentary Committee that looked into this, but they say that their concerns were not taken on board and the law was passed. In fact, the previous iterations of the bill had an exemption for journalists. The two previous drafts of the data protection law had a journalistic exemption. This particular law which got passed, the bill that got passed, does not have it. So there is a concern. Political parties the opposition has now signed a letter, a petition by more than 130 members of parliament and sent it to the Minister of METI, Mr. Vaishnav, and said that we are very concerned about the provisions of this law. So far, there is no response to that letter, although Mr. Jairam Ramesh of the Congress party had written one letter to Mr. Vaishnav, to which he responded saying that there is going to be no weakening of the RTI law. Now, that goes against what is written in the law, but that was his stand that he took. Now, the opposition parties, the India bloc, did do a press conference, which was covered to some extent, but I think much more needs to be done if this has to be stopped. Because unlike the broadcasting bill, which was still in a pre-legislative state, it was still a bill. You know, there was a pushback and the bill did not get passed in Parliament. This is already an act of Parliament. And now for this to be rolled back, it will have to go back to Parliament. The only interim thing that can be done is to say don't operationalize. The law says that every clause, it can be notified at a different time. So we are saying don't notify it, don't operationalize it, take it back to Parliament and amend it suitably. It's a longer process, but if it is not done, then this will be a very dangerous law. There are other questions in this.
So, two things that I'll take up. One is that has a legal challenge been filed? So actually, the correct way of filing the legal challenge would be once it comes into implementation. Because once the rules get framed and then the government operationalizes it, because suppose the government does not operationalize it, then the court might say, why have you come to us? So we are all going to wait for it to get operationalized. We are hoping that the government takes on both the concerns, because the concerns are now coming from a very, very vast cross-section of society. It's not just RTI users, it's media, it's academics, it's researchers. I mean, imagine people who, let's say, research farmer suicides. You're not going to be able to do that kind of research. People who research internal migration, the movement of people to the Gujarat diamond industry, what happens there, then when do they migrate back? All of that is out of the window once this. So we really do hope that the government sort of addresses it, realizes that there are huge concerns. And the law did go through certain deliberative processes. There was first the Sri Krishna committee. After that, there was a joint parliamentary committee. After that, there was also a standing committee. Sri Krishna committee specifically said that media must be exempted. The 2018 law said media will be exempted. The next iteration, 2021, again said media should be exempted. The 2023 version drops it. So to our mind, it's also very deliberate. It's not something that, oh, by mistake, media got included. It looks like it's very deliberate because you've deleted that particular thing. Again, the 2018 and the 2021 versions did not amend the RTI law. It has come into this particular iteration. The JPC had given several recommendations, including saying that let's focus on the big data companies, etc. None of that is on board. And finally, the standing committee, which was looking on this, and this is all available in media reports. This is not something said in private to anyone. The final day of the standing committee that it was deliberating, the government suddenly presented this latest version of the bill and said, this is what we will now propose. And all the opposition members said that we've not even seen it. Like, how can we pass something we've not seen? They actually walked out of the standing committee, and then by voice vote, they finally had a unanimous of all of those present and voting. So it's also very problematic how the process and the deliberations on this have happened. Just one more point I wanted to say, and then I'll hand over to Rakesh. So so the only thing that we've heard from the government is one letter by Mr. Vaishnav when he's replying to Mr. Jairam Ramesh. Otherwise, we've not heard a response to any of the concerns. Now that letter is very interesting. It's a very short letter, just a one-page letter, but it's really worth reading. First of all, he says that we are bringing this law because the Puttaswamy judgment requires us to do this. Now, Puttaswamy judgment comes in 2018. There is nothing in that judgment, absolutely nothing in that judgment that tells the government that media should be stopped from doing its work. There is nothing in that judgment which says the RTI Act should be amended. In fact, that judgment by a huge bench, because finally it went up to the Constitution bench, it is 1076 pages. Not one sentence in that judgment says that RTI Act needs to be amended or press freedom needs to be curtailed. So it's very clear that what they're relying on does not justify these sort of draconian provisions. And the other point where Mr. Vaishnav replies is that he says that there is a section in the law which says that this act will not apply to any information that is made public. I think it's section 3 subsection 4, which says that this would not apply to any information which is made public under any other law for the time being in force. But when you've amended the RTI Act itself, then obviously the RTI will be amended. That means that any information that now I can access under the law. So nothing is going to get saved. And in fact, we've been looking at public databases like the Narega database. A lot of our work is based around these questions of social policy and social welfare. So let's say if you look at the ration database, it's crucial for people to have that access to information, ki kisko ration mila, kisko nahi mila, is my name on the list, etc. None of this is actually protected by law. The law usually just has a broad framework saying there should be transparency. So all of these databases, even what Anjali said in terms of the voter list, there is nothing in law which says the voter list shall be made public. So all of this is also a big question mark.
Yeah, what Mr. Vaishnav said would have been valid if RTA has not been amended. If RTA was not amended, what all he said, that there is protection for existing law and all that would have, అది నిజమే ఇది, కానీ ఆర్టీఐని అమెండ్ చేయడం వల్ల ఇప్పుడు ఎటువంటి వ్యక్తిగత సమాచారం ఇవ్వడానికి వీల్లేదు. కాబట్టి వేరే చట్ట ప్రకారం ఇచ్చిన వ్యక్తిగత సమాచారం ఓకే అంటున్నారు, కానీ అసలు ఆ చట్ట ప్రకారం వ్యక్తిగత సమాచారం ఇవ్వనివ్వద్దు. సో దాని ఈ రెండు కూడా కాంట్రడిక్టరీ, యూనో ఇన్ హిస్ లెటర్ ఆల్సో హి వాస్ కాంట్రడిక్టరీ. Yeah, it has a provision. It has a specific provision. So unlike journalists atla where journalist is not mentioned, that is possible. Yeah, section 44(3) అంటే digital data protection చట్టంలో in section 8 of the Right to Information Act in subsection 1 for clause J, the following clause shall be substituted, namely information which relates to personal information. సో ఇంతకు ముందు ఇది ఏముండేదంటే, ఈ చట్టం రాకముందు ఇన్ఫర్మేషన్ విచ్ రిలేట్స్ టు పర్సనల్ ఇన్ఫర్మేషన్ దట్ హ్యాస్ నో రిలేషన్ టు ఎనీ పబ్లిక్ యాక్టివిటీ ఆర్ పబ్లిక్ ఇంట్రెస్ట్, ప్రొవైడెడ్ ఇన్ఫర్మేషన్ దట్ కెన్ బి గివెన్ టు ఎ పార్లమెంట్ ఆర్ లెజిస్లేచర్ కెనాట్ బి డినైడ్ టు ఎనీ సిటిజన్. ఆ రెండు లైన్లను తీసేశారు. సో ఓన్లీ ద ఫస్ట్ పార్ట్ ఆఫ్ ద ప్రొవిజన్ హ్యాస్ బీన్ రీటైన్డ్. సో ఇట్ ఎక్స్ప్లిసిట్లీ అమెండ్స్ రైట్ టు ఇన్ఫర్మేషన్. ఇంకోటి ఏంటంటే ఈ ఎగ్జామ్షన్ ఆఫ్ డేటా ఫిడ్యూషరీస్, ఇంతకుముందు కూడా క్లాస్ ఆఫ్ ఫిడ్యూషరీస్ ఉన్నారని, దే హ్యావ్ నాట్ మెన్షన్ ఎనీ క్లాస్. వైల్ ద మెన్షన్ ఇన్ పాసింగ్ దట్ వాల్యూమ్ని బట్టి, నేచర్ని బట్టి, స్టార్ట్అప్స్ని వాళ్ళని వి మైట్. సో దేర్ ఇస్ నథింగ్ కాంక్రీట్ ఆన్ హూ విల్ దే ఎగ్జామ్ట్, వాట్ విల్ బి ద ప్రాసెస్ ఆఫ్ దట్ ఎగ్జామ్షన్, విల్ దేర్ బి ఎనీ లాజికల్ ఆర్ రేషనల్ బేసిస్, వి డోంట్. ఐ మీన్ ఈవెన్ ఇన్ ద రూల్స్ వి డోంట్ సీ ఎనీ ఆఫ్ దట్. సో అన్లెస్ దెర్ ఇస్ ఎవిడెన్స్ ఆఫ్ ఓకే విల్ డూ దిస్, దట్ ఈస్ స్టిల్ అ వెరీ బిగ్ కన్సర్న్.
What happens to the information that is supposed to be in the public domain, kept by government or private parties? For example, Election Commission has to post all the affidavits of the contestants, and we are taking those affidavits and say in 2014 he has so much movable, immovable property, in 2019 he has so much. How does he got? We used to question that. Now what happens to this?
So two things. First is that the law defines processing as not just data collection. It also involves any kind of analysis if it is done in a digital way. So now imagine that the Election Commission, under the orders of the Supreme Court, because the candidates' assets and yes, so the candidates' details are given under a Supreme Court judgment. We can say that perhaps it will be treated as law because the Supreme Court said it. It will continue to be there. But if you were to do any kind of publishing of that data now, then that would be covered under this law. You will have to take consent from the person whose data you are going to publish. So publishing, because dissemination, I'll just read out the... Yeah. Yeah, so this says the provision of this law shall not apply to any other person who is under an obligation in any other law for the time being in force in India to make it. No, I'm looking for processing, the definition of processing. Yeah. So processing means it includes collection, recording, organization, structuring, storage, adaptation, retrieval, use, alignment, indexing, sharing, disclosure by transmission, dissemination, or otherwise making available anything, any personal data. So the Election Commission of India might be making some data available in the public domain, but as a journalist and your organization, if you have to use that data and disseminate it in any form, you will need consent because this law will kick in. So this is very problematic. And the other thing which you were talking about, that how does this kind of hit
because of any other law enforcement, etc., is what it says. But what if these very organizations start interpreting this law and start removing that information? Then it becomes, personal information. So what will happen with all the information that is already in the public domain is a question. Nobody knows. It might remain in the Election Commission, or anybody might say, but somebody might go to court and challenge that this is my personal information. And so it's a tough question.
No, so that is one thing where information is there under a law, it will remain. So the candidate's information, for example, if it is under the Supreme Court or a judgment, it is likely to remain. Nothing will happen to that. But the use of it and any kind of processing of it, this law will kick in on those people who are processing it. It doesn't matter that the Election Commission got consent. The Election Commission got consent to put it on their website. But for you and I to put it on our own stories or websites, we will need consent from the people whose data we are publishing or using or in any way processing. Every data fiduciary, because if you are processing or publishing that data, you also become a data fiduciary. It's not just the ECI. On retrospective effect, there are two things again. One is that this law says that any information that you might have already collected, you will now at the earliest have to go and take consent from them. Otherwise destroy that data. So you can't hold any personal data till you have consent. The other thing is that a lot of data used to be put out in the public domain by the government under the RTI law or under different laws. Now, for example, Manrega data, who all are getting wages under the Narega works. That was put in the public domain. Who is the beneficiary under the public distribution system of the National Food Security Act used to be put out. This was because government said that this is important for public accountability. There was a long debate and the governments were asked to put this out. They started putting it out. Now they will say that the law simply says, the Narega law or the National Food Security Act simply says details of beneficiaries have to be out. Now details could even be the numbers. Details could be 80 crore people in our country get rations. That's a detail. So there is nothing in the law which says the name of the beneficiary has to be there. So that is also likely to go. So the data sets that people relied on in the past because they were put out in the public domain are most likely going to be removed. Like I said, the Election Commission of India, which was putting out the voter lists, could also turn around and say after this law comes that this is all personal information. Now there is a data protection law in place. We cannot put out this kind of information because that is in any case not under any law. The Election Commission is putting out the data on its own because they feel, except for candidates. So, yes, the electoral bonds judgment was a fantastic judgment, but we had to wait 7 years for the judgment to come. So, the question that you said, that will it be challenged in court, what people understand is that even if there is a progressive judgment that is given, it could take 10 years to come. The RTI law was amended in 2019. And a challenge was made in the Supreme Court. Not a single substantive hearing has happened till date. We are in 2025. So, how much hope can one have? And in the meantime, so much changes, so many media houses will shut down because they can't risk this kind of penalties. So much investigative journalism will be lost. So many people will lose their right. So that is a problem.
Just wanted to add two things. One is that it's also going to have a huge impact on small and medium business enterprises, because the large corporations, they can pay a legal firm 12 lakh, 15 lakh rupees, have a contract that you handle all our consent framework, etc. Small and medium industries are really, really going to get hit. And already, like, some people had reached out saying, I run a small publishing house. Whoever comes to our bookstall, we collect their phone numbers. Then we start sending them flyers and announcements of new books. All of that gets hit by this date. So even people who have WhatsApp broadcast lists, you will become a data fiduciary. That's the nature of this law. Now, I'm just going to read out one provision of the law. It's slightly technical, so if you just bear with me. This concerns this issue of that what will happen to data if it's made public under a law, but if we are processing it. So it says the provisions of this act shall not apply to personal data that is made or caused to be made publicly available by the person to whom such data relates. So for instance, if I go and put out my own information on Facebook or Instagram, I will not get fined by it. B, any other person who is under an obligation to make such data publicly available. So now the question will come that if you go and process, let's say, the candidate affidavits, will you be able to prove that you are under an obligation to do this processing? And I think over there, most of us will. Yes. So it'll reach the. Is there a legal obligation to? So this B1. So this is something that we've been really trying to wrap our heads around, that. And the example is very interesting. So they've given an example in the law. So for instance, the question on if I make my own data public, what happens? It says X, an individual, while blogging her views, has publicly made available her own personal data. In such case, the provisions of this act will not apply to her. So you see, that's the question, that what happens to all of us who use publicly available data to run analysis, to get to the bottom of things, to investigate things. It's really going to fall into this question of that, were you under an obligation to do this? And I think most of us will not be able to meet that question.
So can I just take 1 minute to say that one thing that has been decided was that, these discussions when they happened in Delhi, that if journalists from across the country were to write to the central government and say that, look, there needs to be journalistic exemption for any of a law like this. In most countries has journalistic exemption. So before you operationalize the law, please amend it in an appropriate manner to give journalistic exemption. The other is that a lot of journalists who do investigative journalism use the Right to Information Act to say that this will prevent them from being able to access a lot of information. Some rely on sources, but others also rely on right to information. So that amendment should not be operationalized. And this will require two kinds of things. On the right to information, the simple demand can be that don't operationalize section 44 of the RTI Act, of the Data Protection Act right now. But for journalistic exemption, it will need an amendment in the parliament. So the proposal was that a petition could be drafted which could be signed to be sent to the minister, because there are citizens who are writing to the government and they are doing it across the country. The government might or might not respond to that, but when journalists write and they specifically talk about their concerns as journalists in terms of this law, it will probably have an impact, and the government might listen at least on those, because I mean the idea is that this law is hitting so many aspects of democracy, and free media is something that concerns all of us, free press. So if that is something that can be done, it would be most useful, and perhaps in this is something that can be done collectively by different media bodies. The Editors Guild wrote this letter some time ago, but press clubs across the country, journalist bodies across the country, if they could also write one petition to the government, it would be powerful.
Thank you. I think this bill is not only going to kill investigative journalism, but also data journalism. Remember, we had a big session on data journalism. Rakesh was telling how data journalism can be so powerful. Now there won't be any data journalism if this comes into power. You want to ask? Rules frame, Kalaga.
Thank you, Anjali, Amrita and Rakesh, for a very insightful session. In fact, as journalists, we were not aware of the dangers of this act itself, and it was such a vast information, the actual inefficient mind, which actually got to know now. And as you said, I think as Press Club, we'll definitely go ahead and take up this issue. We'll write to the minister, the concerned minister, Mr. Ashwini Vaishnav. And I think I'll request the unions here, which are quite strong, the journalist unions, to take up this issue, and maybe we'll have a roundtable kind of thing, and they'll forward that to the ministry itself from the Press Club of Hyderabad. In fact, as a journalist, I'm ashamed that I was not aware of such dangers. The only thing I was exposed about this act was the letter written by Mr. Jairam Ramesh and the response of Mr. Vaishnav, because it was published in our newspaper. So that's the only thing I got to know about this act. Thanks for giving so much information and enlightening all of us here. As you suggested, we'll definitely take it up, and from the Press Club of Hyderabad, we'll do something at least to protect, and we'll be part of your campaign that takes this issue to a national level. Thank you very much.